I'm Geraldine Elliott. I head the Commercial Litigation team, and I'd like to talk about some of the areas that we're seeing in the market at the moment. One is that GCs and in-house counsel sometimes find themselves under pressure from the business as they're seen as a cost to the business. We see them as being able to turn their function into profit for the business. So how does that work? There will be times when business partners haven't fulfilled their contractual obligations, and why not seek redress, and seek redress through the courts, through litigation? Now, I know that FDs see that as potentially risky and potentially costly, but there are ways of managing that risk and managing that cost. First and foremost, in managing risk, in-house counsel will be making sure that they collect in all the information that's available in relation to the contract, in relation to where it's gone wrong, in connection with that business partner, and making sure that they have that risk thoroughly assessed from the outset. So the risk is manageable. And on cost, it's not just about spending money. First of all, that money will be recovered. If you've managed the risk appropriately from the outset, you will be most likely to recover that cost. But there are other ways of offsetting the costs and taking it entirely off the balance sheet. There are litigation funders who will finance the litigation. Yes, they will take a share of the upside in the litigation, but it is a way of proceeding in effect off balance sheet, with the finance director knowing comfortably that the cost of that litigation will never hit his bottom line. And there's a third factor in all of this, and that's the management time that has to be invested in litigation. And there's a perception that litigation isn't justified by the cost of management time. And sometimes that's true. But there are times where throwing into the balance the upsides, managing those risks, managing the costs, that ultimately the balance between management time and the reward weighs in favour of the reward. Nobody goes into these endeavours lightly, and it's absolutely critical for businesses to make sure that they have all the information that's available to them before they make the decision. And what I'm saying is, don't forget about that management time, but don't regard it as the determining factor which will always militate against enforcing your contractual rights. So there are a number of centres of legal excellence in the world, and London is one of those. And why London? Long history of law. We have a very prominent financial centre, and around that we've developed very sophisticated legal processes. And we have a fantastic judiciary. These are not career judges. They are lawyers, barristers who've reached the pinnacle of their game as practicing lawyers and have become judges. They're very smart people, and they're highly regarded around the world for their independence of mind. And as a result of that, we have been able to build up a body of precedent, which means that litigants coming here to London will find that they have a reliable judicial system, and one that has much more predictability in it because of our system of precedent than many other of the competing jurisdictions over the world.